Sadakta mtazamaji, zimetimia saa 10 majira ya alasiri saa za Afrika ya Mashariki. Natumai mzima wa afya popote tunapotegea taarifa hizi. Karibu ni kujuzi yaliibuka na kugonga vichwa vya habari kwenye taarifa za mbiu ya KTN. Jina langu ni Hadia Mwasiwa na kusihi usalie nami kuanzia sasa hadi tamati mwa taarifa hizi. Na moja kwa moja tukianza, tuzamie taarifa ifuatayo ambapo Mahakama Kuu ya Kiambu imetupilia mbali ombi la kusimamishwa kwa kuwasilishwa kwa majina ya kamati ya kuwateuwa makamishna wapya wa tume ya uchaguzi na mipaka nchini IEBC kwa Rais William Ruto. Jaji Dora Chepwoni vilevile hii leo alisema ombi hilo halikuwa na msingi, akisema majina hayo 9 hayana kosa lolote na yanaweza kuchapishwa ili waanze rasmi na kuwateuwa makamishna wapya wa IEBC.
Has advanced insufficient evidence and grounds to warrant it to declare the overall process of constituting the selection panel as having contravened the provisions of Article 10, Sub-Article 2 and Article 54, Sub-Article 2 of the Constitution. The court finds that based on the material before it, the petitioner's arguments remain and stand largely unsubstantiated and uncorroborated. Hence, it cannot invalidate the minority coalition party's nomination solely on speculation. Having established that the petitioner has not proven the alleged constitutional and statutory violations, the main orders being sought to declare that the panel lists offense Articles 10 and 54 of the Constitution and certiorari to quash the list are not merited on the available evidence, and consequently this petition is found to lack merit and is therefore dismissed. Whereas it's not disputed that the final list containing the required 9 nominees does not include a person with disability, the petitioner has failed to demonstrate that any qualified person living with disability applied or was proposed for nomination but was overlooked is persuaded that 9 nominees reflect an overall attempt to ensure regional diversity. The petitioner's assertion that 4 nominees are from 2 specific ethnic groups standing alone is therefore insufficient to invalidate the entire process. The court also observes that the minority coalition party was not joined in these proceedings that the minority coalition party, the very entity whose process the petitioner impugns, was not joined in these proceedings as a party, and therefore there is a rule against condemning a person without or an entity without hearing, and this equally applies in constitutional cases. The court's conclusion that the petitioner has failed to discharge the evidential burden as required under sections 107 and 109 of the Evidence Act to show that the minority coalition party defied or subverted the High Court orders or the statutory procedures as he alleges.
Hayo yakijiri, waziri wa